For those of you who want to open carry a firearm in Florida, well, today is a day to celebrate. We have a huge ruling that came out of Florida's first DCA today, and it looks like Florida's ban on open carry might be a thing of the past. Be sure to stay tuned. Hello everyone, and welcome to the Firearm Firm channel. I'm attorney James Phillips, a founding partner of Katz & Phillips PA and co-author of Florida Gun Law, Armed and Educated. Today we're talking about breaking news that just came out of Florida's first DCA regarding open carry of a firearm in the Sunshine State. This morning, a 3-judge panel declared that Florida's ban on open carry is unconstitutional. That's right. Florida Statute 790.053, which bans the open carry of a firearm minus a few exceptions, has been found to be unconstitutional. The decision comes from the case of McDaniels v. State of Florida, which began as a criminal case. In this case, Mr. Stanley McDaniels, a true 2A patriot, decided to go stand at a major intersection in Pensacola, Florida, with a copy of the Constitution and wave at cars passing by, while having a holstered handgun in his waistband that was visible to the public eye. As you can imagine, law enforcement was called out and they approached him, and he was very cooperative with them, and he explained to law enforcement that he wants to take the case to the Supreme Court. Ultimately, a warrant was issued for his arrest for violating Florida Statute 790.053, and prior to trial, he filed a motion to dismiss the charge and to have Florida's open carry ban declared unconstitutional under the Second Amendment to the United States Constitution, both facially and as applied to him. After a hearing, the trial court denied his motion, but they certified a question to the Court of Appeals as one of great public importance. The question was, does Section 790.053 Florida statutes violate the Second Amendment right to bear arms in public, considering the nation's historical tradition of firearm regulation? Let's take a look at this well-written order, which I will attach down in the description section in its entirety. The court first ran through the Heller and McDaniels decisions and how courts prior to the Bruen decision used a 2-step framework for evaluating Second Amendment challenges, and how the Florida Supreme Court in the Norman case had used that same framework to find that Florida's ban on open carry was constitutional back in 2017. In discussing the Norman decision, the first DCA wrote, applying the 2-step framework, the Supreme Court first held that Florida's open carry ban burdened conduct within the scope of the Second Amendment because it restricted one manner of bearing arms for self-defense. At the second step, the court determined that the ban related to the core of the right, since it limited public carry where a need for self-defense exists, but it concluded that the restriction was not so close to the core as to foreclose the ability to protect oneself, given Florida's permissive shall issue concealed carry licensing regime. Viewing the burden as not severe, the court applied intermediate scrutiny and found that the ban was constitutional. Now, in 2022, the United States Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen changed the playing field for the Second Amendment challenges. The Bruen decision did away with the 2-step test, and the U.S. Supreme Court wrote in Bruen, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. The first DCA turned its attention to applying the Bruen analysis to Florida's ban on open carry. As to the first part of the Bruen analysis, the court wrote, the state does not dispute that Florida's open carry ban targets conduct protected by the Second Amendment's plain text, nor could it credibly contend otherwise. Now that the court determined the regulation fell under the plain text of the Second Amendment, it was up to the government to show that the restriction is consistent with the nation's historical tradition of firearm regulations. The government, I'll give them a hand, did try their best to do so, but ultimately the court found that they had failed to meet their burden. Now, if you are interested in knowing more about how the government tried to meet their burden, be sure to click on the link down in the description section of this video to review the order. The state's attempts begin on page 11 of the order. So in their conclusion, the court wrote, "The Constitution protects the right to carry arms openly for self-defense. Florida's open carry ban cannot be reconciled with that guarantee. Section 790.053 Florida statutes is therefore declared unconstitutional. We answer the certified question in the affirmative, reverse McDaniels' conviction, and vacate his sentence." Congratulations to Mr. McDaniels for standing up for our Second Amendment rights, and congratulations to my friend and fellow Second Amendment attorney Eric Friday for fighting the good fight. Great job, Mr. Friday. So, does this mean that you can strap on your AR-15 and open carry throughout Florida? No, not yet at least. The government has the option to seek the Florida Supreme Court intervention in this case, along with some other procedural moves that they could make. So check back in about 30 days. Be sure to let us know what you think about this ruling down in the comments section, where you can also leave any questions you have about this video or any other Second Amendment related questions. Till next time, stay armed and educated.